So imagine you get a message from a potential client, and this potential client says that they were almost involved in an accident. And after this incident, they have been suffering from serious mental distress. What do they mean by almost involved in this accident? They explained that one night they were driving on the motorway and a huge truck was behind them, and they were fearful that the truck was going to hit them. They then swerved onto the roadside, fortunately, and when they swerved, this meant that the truck did not ultimately hit them. So there wasn't any physical impact and thus no physical injury to this potential client. However, following that incident, they have been suffering mental distress, and they wish to start a claim in negligence for damages. The question is, even though this potential client did not suffer any physical injury, could they have a successful claim in damages in English law? Hi, I'm Denise, and you're watching Law with Denise. So yes, in English law, claims for damages in negligence can be established, one, for physical injury. So if the claimant had suffered physical injury and wanted to make a claim, providing that the defendant was negligent, that could possibly be established in court. If a claimant also wants to claim for damages for psychiatric injury when physical injury has been caused, that's also permitted. So if he had suffered physical injury and in addition to the physical injury, he was also suffering mental injury, he could claim for the mental injury as well. Additionally, if a person has not suffered any physical injury, but they have been involved in an incident and they have suffered mental injury only, a claim can also be brought in English law. We call these pure psychiatric injury claims. So yes, this potential claimant has a potential case. But there are particular things that we need to discuss, we need to establish in order to determine whether or not he could be successful. The first thing is that this potential client needs to be aware of the distinction between what the court refers to as primary victims and secondary victims. Now, in Page and Smith 1996, the Lords did confirm what the difference between primary and secondary victims is. This was previously discussed in Alcock and Chief Constable of 1992, and in Page and Smith, they did confirm it. Now, what they said was that a primary victim is someone who is involved in the incident, and then a secondary victim is someone who witnesses the incident. So in our scenario, the potential claimant is a primary victim because he was involved in the incident. He was in his car and he was the one who swerved to the roadside. He was not on the side watching another person swerve to the roadside. If he were, then he would be classed as a secondary victim. In addition to establishing whether or not this potential claimant is a primary victim, this potential claimant, or any claimant who wishes to start a case for pure psychiatric harm, needs to convince the court that they are suffering from a recognized psychiatric illness. Now, what this means, as we saw in cases like McFarlane and O'Brien and Attia and British Gas and Rayleigh and Merseyside Health Authority, is that the court does not recognize normal human reactions to dangerous incidents as recognized psychiatric illnesses. So mere grief and sorrow, these are not recognized. Nicholls and Rushton from 1992, where the plaintiff was involved in a road accident and he claimed that he was in shock and he was shaken up. Even this was not recognized by the courts. What the courts are interested in, or what the courts have accepted as recognized psychiatric illnesses, are things like anxiety neurosis, which they recognize in Chadwick and British Transport Commission. They've also recognized a personality change. They've recognized reactive depression, and they've recognized post-traumatic stress disorder in quite a few cases, including Alcock and Chief Constable of South Yorkshire, McFarlane and EE Caledonia, and Hegarty and EE Caledonia. So this needs to be discussed with this potential client. If what he's suffering from is not a recognized psychiatric illness, then the court will not be interested. Now, in addition to this, he will need to convince the court that he was in fear of personal injury to himself, Dulieu and White. So what this means is that when he was in this incident, during that time, while he was experiencing the incident, he had a fear that he was going to be injured in some way. Following Page and Smith 1996, it's important to note that the plaintiff doesn't have to convince the court that they were in fear of either physical or psychiatric injury. The Lords confirmed that the only thing they are concerned with is if the plaintiff was actually in fear of personal injury. And when we say personal injury, that covers either physical or psychiatric injury. If the court is convinced that the plaintiff was in fear of some personal injury, that is physical or psychiatric, it is irrelevant what type of injury they actually sustained. So in our scenario, as long as the plaintiff can convince the court that they were in fear of some injury, it doesn't matter that the injury they actually sustained was pure psychiatric harm. That's enough. In some situations, the court may accept claims from people who were not in the place of danger when the incident took place, as we saw in Young and Charles Church from 1997. So in that situation, the plaintiff was not actually in the place of danger when he developed his fear. In fact, he went back to returned to a scenario where he saw that his workmate had passed. It was the aftermath of the dangerous situation which causes fear. Now, with our potential client, the Young and Charles Church is not relevant because our potential client was actually in the place of danger. But it's important to note that sometimes the court will accept such cases which involve plaintiffs who are not in the place of danger, but visited the aftermath and then developed their fear. Lastly, it's important for our potential client to understand two things. One, they need to demonstrate to the court or convince the court that their fear was reasonable. It's not enough that the fear was genuine. It needs to be reasonable. And this is going to be determined by the courts. But even if the court is convinced that their fear was reasonable, this will not be sufficient, as we saw in McFarlane and EE Caledonia. What the courts will then ask after they're convinced that the fear was reasonable, the courts will then ask if it was reasonable for the defendant to have foreseen that the plaintiff could have been caused injury. Now, if they are convinced that the plaintiff was in reasonable fear of danger or of their safety, and they are convinced that the defendant ought to have reasonably foreseen that the plaintiff would have been in fear of injury, then they are likely to establish that a duty of care is owed to the plaintiff.